Good evening, everyone, and welcome to the Donia Human Rights Center panel entitled Detaining Refugee Children, What's at Stake. My name is Kiyoteru Tsutsui, and I'm the director of the Donia Human Rights Center. The issues around asylum seekers, immigration, refugees, those are major political issues for some time, and we at the Donia Human Rights Center have been wanting to tackle this question for some years, and I'm delighted to welcome you to this panel. And I also would like to thank our co-sponsors, Ford School of Public Policy, Law School, and School of Social Work, all at the University of Michigan. There are said to be about, I'm not gonna lay out all the issues because I wouldn't want to steal thunder from our panelists. There are said to be about 20 to 30 million refugees in the world. Half of them are thought to be children. And the issues of refugee have hit Europe particularly hard a few years ago. And now this past spring to summer, May to June in particular, the issue really came to a head in this country as the Trump administration implemented the so-called zero tolerance policy, separating children from adult asylum seekers. And there's always new scandals and political issues in this administration. So this particular issue has somewhat faded into the background. But after a few months since the peak period of attention for child refugee issue, we wanted to assemble this all-star panel from this campus to address the topic and try to gain deeper understanding of this issue of separating refugee children from their parents. So for this panel, we have three speakers, Professor Sherry Kusuji, Professor Ann Lin, and Professor Jim Hathaway, and I will introduce them briefly, and then they will speak in the order that I introduced them. They will each speak about 15 minutes, and I would like to make sure that there will be plenty of time for questions and answers. Professor Sherry Kusuji is an associate professor in the School of Social Work and an adjunct associate professor in the Department of Economics, and her research focuses on issues around migration and immigration, and she has written a number of articles on the legal status of immigrant workers in the U.S. and the incentives for them to cross the border. And she is now launching a new project on refugee movement and asylum policies around the world, so it's particularly timely for her to speak on this issue. The second speaker will be Professor Ann G. Lin. She is associate professor at the University of Michigan Ford School of Public Policy. Dr. Lin has studied immigrant political socialization, the interface between immigrants and the government authority in their new home country. And she is has been a co-principal investigator on the Detroit Arab American Study landmark public opinion survey of Arab Americans in Detroit, and also a co-author of a book on the study Citizenship in Crisis, Arab Detroit After 9/11. And she is now engaged in a collaborative project looking at the methods to reduce bias against Muslims into metro Detroit cities. And last but not least, Professor James Hathaway. He is the James E. and Sarah A. Degan Professor of Law and Director of the Program in Refugee and Asylum Law at the University of Michigan. He has been teaching at many different universities all over the world, has been Dean of Law School at University of Melbourne. He's taught in Canada, Japan, Australia, New Zealand, all over the world, and his work on international laws around refugee and migration have been translated, published in English and then translated into Russian, Japanese, Chinese, and others. He's a foremost expert on international law on refugees. So we are particularly delighted to welcome all three speakers, and please join me in welcoming all three of them. So we'll start with Professor Kasuji.
So hello to everyone, and thank you for coming out on this first frigid night of the winter season. I have to say that describing the effects of the zero tolerance policy on children is a little bit like explaining Game of Thrones in a one-page essay, but I'm going to try. I'm going to skip a lot, and please feel free to talk to me later if you're interested in data sources or quotes that I've made, because I'm not going to document it as well as I might in a longer talk. So until about 15 or 20 years ago, mostly single adult men from Mexico represented migration across the US-Mexico border. Right? What that meant is that we didn't have to pay attention or know anything about children in detention or families in detention. But in the early 2000s, roughly, unaccompanied minors started coming in larger numbers, and family units started coming in larger numbers, and they were apprehended in larger numbers. Now, when an unaccompanied child crosses the border and gets apprehended by a Border Patrol agent, that, and I have to say, is from Central America or any other non-contiguous country to the United States, right? That child is detained, and they spend a short time in detention facilities of the U.S. Customs and Border Patrol. Not supposed to be more than 72 hours. Then they are transferred over to the Office of Refugee Resettlement, where they go into longer-term custody, and they stay there until they can be released to a relative, to a guardian, or to a foster family. So just taking a quick look at this graph, in 2004, there were approximately 6,000 unaccompanied children who were referred to the Office of Refugee Resettlement and put into longer-term custody. Throughout the wars and the conflicts in different countries in Central America, the migration of children increased rapidly. Many of you probably heard about 2014 and what happened in that year. Even in 2018, we're still seeing about 50,000 unaccompanied minors apprehended, and the majority of those are placed in the care of the Office of Refugee Resettlement. We didn't even have a discussion about family unit apprehensions until the past few years, and data wasn't even kept, or statistics wasn't even kept on family units because there were relatively few of them that were apprehended. And the idea of family separation, which existed before the Trump administration, was also relatively rare. The way that I get my statistics is always a little convoluted, but what I can tell you is that in 2013, there were 77 family units per night in detention in ICE facilities. Okay. By 2017, there were 1,407, and in 2018, we don't know the final figures yet, but there are allocations for 2,500 family unit beds per night. So what's changed? What has changed is that the way the administration detains children is now a conscious part of the policy that's called the zero tolerance policy. If we take a look at this graph, we can see that out of all of fiscal year 2017, there were about 75,000 family unit apprehensions, and there were approximately 1,000 family separations. The second blue bar is for the first 5 months of 2018. You got to get your data where you can, right? The last 3 bars are different time spells during the 8 weeks of the zero tolerance policy. And in fact, if you take a look at the last bar, there were about 1.5 times as many family separations in the 8 weeks of the zero tolerance policy than there had been in the 17 months before that. So what do we know about family separations? Well, Jeff Sessions made it really clear in April when he noted that the zero tolerance policy was aimed at deterring unlawful border crossing. And he stated that if parents do not want to be separated from their children, then they should not bring them across the border. And I should warn you that I'm ignoring a whole bunch of asylum issues here, right, about rights and responsibilities. I just want to alert you to some of the things that we know have been happening. President Donald Trump also made it clear that the separation of families was in fact a negotiating tool to get Democrats to cave on his immigration demands. Further, we know that this is a conscious part of the policy. We know that this was at the core of the zero tolerance policy. There may well have been no intention to ever reunite children and parents as a result of this policy. Are you going to talk about the records, Ann? I'll let Ann tell you all about the records. Okay. By August 3rd, less than 3/4 of the children had been reunited that were ordered to be reunited within a month of June 19th. It was clear that many of the parents had been deported with no opportunity to reunite with their children, and the administration was not successful and not even working very hard. I'm sure people were working very hard, right? But really weren't putting a concerted effort into reuniting those families. By August 27th, only 81% had been reunited. There's a flurry of lawsuits going back and forth about this. The administration gets upset at the ACLU and says, why don't you use your resources to reunite them? That's non-legalese of what the lawsuit actually said. In case you wondered, as of the last report on October 15th, only 89% of those kids have been reunited with their families. We can talk about the reasons for that at some other time. So both adults and children in detention have defined rights. And yet, what we have seen and read about and heard about over and over and over again are reports of neglect, reports of abuse, and widespread indifference to the well-being of children, families, and adults in immigration detention. Okay. The first accounts started coming in almost immediately as soon as this policy was implemented. Border Patrol agents were apprehending and separating so many children that the Office of Refugee Resettlement didn't have the ability to take them on. And so the first reports were talking about how children were being kept in Customs and Border Patrol detention areas. Anybody ever seen these? They're jails, right? And for longer than the 72 hours, they often had no oversight. They often had little in the way of reasonable food, blankets, toys, books, anything that you might think of as something reasonable for us to do with children that we detain. Reporters were allowed to visit the McAllen Customs and Border Patrol facility. This is just some of the things that were said. This is the McAllen facility, right? The eyewitness accounts were that hundreds of immigrant children wait in series of cages, created by metal fencing. The administration says those are not cages, those are metal perimeter definition somethings, right? One cage had 20 children inside. Scattered about are bottles of water, bags of chips, and large foil sheets intended to serve as blankets. One lawyer who was in the center talked about a child who was so traumatized that she was curled up in a little ball, right? She wasn't talking. She was essentially catatonic, right? Now, you may not know this, and it was probably devised for the safety of the children in detention. But the staff members in those detention centers aren't typically allowed to touch the children. And what does that mean? What that means is that if a child is crying, if a child is frightened, if a child has nightmares, right? If they're terrified, nobody can hug them, nobody can touch them. So this started a scrambling for defined shelters. These are detention facilities in the United States. It's both criminal detention and immigration detention. A lot of immigration detainees are being kept in criminal detention centers now. I have circled 3 of them because they're important to this whole zero tolerance story. The orange circle is the Southwest Keys Immigrant Children's Center. That's the one where they took an abandoned Walmart and turned it into a children's detention center run by a nonprofit called Southwest Keys, which has had a lot of complaints against it. The second is the Southwest Texas Family Residential Center. That's the green circle. That's also called the Dilley Detention Center, and that's where a lot of families are held. The third is the Tornillo Tent City that you've all been hearing about. It's out in the desert, about 30 miles outside of El Paso, right? They just moved 1,200 or 1,600 kids there in the cover of night, flying them in from all over the country in order to populate that tent city. Children interviewed after being released talk about feeling like a prisoner, like a dog. They suffer from regular nightmares. They say they were told to behave or you'll be here forever. They're not allowed to touch other children. Remember, the adults are not allowed to touch them. They're also not allowed to touch other children. The rule is un brazo de distancia, right? Everybody has to keep an arm away from everybody else. Okay. Each of us, I'm sure you have heard the horrific stories of trauma inside these centers. We cannot yet be sure just how prevalent these abuses are. I mean, we're living in this moment to moment. Sometimes I give talks and everything I'm talking about changed an hour ago, right? But we will find out just how prevalent these abuses are in these detention centers. So we can sort of broadly categorize the effects of children living in detention by thinking about both the short-term consequences and the long-term consequences, okay? First, think about the social and emotional distress and its consequences. Many of these children have already been diagnosed with symptoms like PTSD, okay? That's something that carries on for many years. Second, the physical and mental health of the children, the consequences of both the trauma and the medical neglect. Third is the short-term and long-term disruption to the family unit. I'm sure you've read about mothers finally connecting up with their children, being released from detention, opening their arms for their children, and the children turn their backs to them because the children are so traumatized and the children think that maybe mom did this to them. Poor educational outcomes in the longer run. Of course, we require them to go to school while they're in the detention centers, so I know that they're keeping up with their studies. And finally, surprise, surprise, a mistrust of law enforcement. Those are the guys, here's one of them right there, who did this to us. Now, as a result of being told that they had to stop the policy, one of the things that this administration is doing is trying to keep families together, wiggle around Flores and a whole bunch of other agreements, and keep families together, right? And ICE assures us on its website that it is totally in compliance with national detention standards and so forth, right? But the Homeland Security Inspector General, notice that's Homeland Security's Inspector General, just released a report, right, saying that although ICE shows 100% compliance in 2014, 2015, 2016, and 2017, they say the scope of ICE's contracted inspections is too broad. ICE's guidance on procedures is unclear, and the contractor's inspection practices are not consistently thorough. Even then, ICE does not adequately follow up on identified deficiencies or consistently hold facilities accountable. Now, the callousness of these detention centers, I just heard Shaylin Fluharty speak. She's the director of the Dilley Pro Bono Project, that Dilley Family Detention Center I was telling you about. And she was talking about how every day she walks into the center and she passes a sign that says, "This facility is not safe for pregnant women," and then meets her client, who's sometimes a pregnant woman. So let's close out thinking about this administration and zero tolerance policy by taking a look at how this policy enactment is in fact in line with what we have seen in every single piece of administrative policy activity related to immigration. What's the first? The first is that this policy hasn't only failed to take account of the best interest of the child, to make it paramount, which is what we're supposed to do, right? But in fact, it has deliberately pursued actions that were certain to create separated children and were likely to increase the level and the longevity of a child's trauma. Second, how many of you were paying attention while all of this was going on, watching all the news reports and so forth? Administration officials initially denied there was any harm whatsoever done to separated children, right? And if there was, it doesn't really matter because the adults were warned and they deserved what happened to them. Third, this administration has used the language of abuse in this policy, and it's done it very carefully and surgically. I will take your children away from you, right? If you do this, I will remove your children. I will take your children away from you. That's not my doing, right? I'm just following the rules. And I can't help it if you get hurt in some way. So enfolded in this policy is a real language of blame. Finally, detention, come and hear another talk of mine sometime. Detention is in fact a policy that's been rising over time, okay? And especially in this administration. Because detention aligns very well with an immigration policy that's based on the idea of securitization, right? You could strategically use securitization and the fact that we are insecure in order to keep the enforcement going to make us more secure. Why is detention so important? Because detention is in-your-face immigration policy. If people are deported, they disappear. If people are in detention, right, then we know that the government is actively working to keep us safe, right? We see that immigrants are dangerous because they're in detention. And we become more fearful of immigrants because the administration is telling us that that's what we need to do. And while the next person, Ann, is walking up, I'm going to leave you with a whole bunch of numbers so you can also see just how expensive this all is. Thank you.
All right, well, Sherry, I think has done a fantastic job of sort of showing you where we should see the impacts of this policy. I'm going to take a little time and show you how this policy came to be. But we might start with the question of what kind of a crisis are we in? Whose crisis is this? If you look at the United States, and I'm going to switch out of this and go to a graph that I did not put on my slide. Let me figure out how I'm doing that. Okay, right there. Let me do that. This is a graph of people apprehended at the southern border. And when we say the southern border, one of the things we should notice is that by U.S. law, the border is 100 miles from the border of the country. And so, for instance, if you apprehend somebody here in Ann Arbor, you can be prosecuted for crossing the border illegally because we're within the border region, okay? So this is apprehensions at the border. And one of the things I want you to notice is that 2017, which is right down at the edge of the graph here, is low, right? What we're looking at is a long-term decline in apprehensions at the southern border from 2000 on down. 2000, when we had about 1.6, 1.7 million. Now, why was it so high in 2000, and why has it been declining? The years around 1999, 2000, 2001 saw a combination of political upheaval and natural disasters in the Northern Triangle area. So we're talking El Salvador, Honduras, and Guatemala. In addition, around the 2000s, we're still seeing a relatively high migration, undocumented migration coming over the border from Mexico. And both of those things have changed. That is, Central America is still in crisis, but the crisis didn't just happen. It is now a crisis that people have been living with. And as Sherry mentioned, a lot of the migration population from Mexico has changed. One of the most important reasons for that change is a change in enforcement policy under both Republican and Democratic administrations, which has led people who currently might have been on sort of a circular migration route. They might have come to the US to work for a couple of years and then gone home, or come to the US to work in certain parts of the year and then gone home at other parts of the year. The increase in enforcement activity at the border and the consequences of that enforcement activity, that is, if you are arrested, you can no longer leave on your own. You actually can be hit with a 3 or 5 or 10 or 20-year ban that prevents you from coming back to the US legally, right? So if you've been found to have come to the US without permission, you can be then prevented from coming through legal channels. And so that combination of policies has really caused a lot of people who might have otherwise been on this circular migration route to stay in the US. And at another time or later on, we can talk about how that's really changed what the undocumented population looks like in the US. One of the big changes is this importance of mixed status families, that is, parents who might be undocumented with children who came to the US with their parents and therefore are undocumented but have for all intents and purposes grown up in the US, and then younger children who are actually born in the US and are then citizens. All right, so part of what the point that I want to make here is the US in a crisis? Well, if you look at these numbers, it's not clear that at least that we're in a crisis of people trying to flood the southern border to get into the US. The other thing I wanted to show you is this great graph where look at the yellow line, the tan yellow line is the unemployment rate in the US, the blue line is apprehensions at the southern border. And what you should notice is that the two have sort of an inverse relationship. When the unemployment rate in the US goes down, in other words, there's lots of demand for workers, people come to, unemployment rate goes down, apprehensions go up because people are migrating to the US for work. On the other hand, when the economy in the US is bad, the unemployment rate goes up, people stop coming because they're coming to work. So you might notice the inverse relationship, and then I want you to notice at the at the end of the graph, 2012, 2014, 2016, the unemployment rate is going down. We're looking for workers. You would expect apprehensions to go up, and what you're instead seeing is sort of a flattening out, right? And that suggests maybe that something else is going on that's both causing people not to come, but then also causing this sort of steady migration flow. All right, so from the U.S. point of view, back to this, and to that. So from the U.S. point of view, it's hard to see why we think the U.S. is in a crisis if the crisis is defined as people flooding over the southern border to take advantage of the U.S. On the other hand, if you look at what's happening in the Northern Triangle, so these are the countries of El Salvador, Honduras, and Guatemala, you might indeed think that they are in a crisis. So just one sort of note, if you look at the per capita murder rate, 2015, these are statistics that are collected by the United Nations. El Salvador has the highest per capita murder rate in the world. Honduras has the third highest. These are very tiny countries, right? And that, of course, suggests that there's important violence, important trouble happening within those countries. Guatemala is 10th on that list. There's also this very interesting recent study that tries to decompose what's going on in terms of economic factors, that poverty leading people to migrate to the US from the Northern Triangle, and then this problem of violence, gang activity, the inability of the government to control crime and gang activity. And basically what the study finds is that if you look by city and you look at the murders within particular cities in these three Northern Triangle countries, you look at the period between 2012 and 2018, each additional murder, it's 2010 to 2016, each additional murder in a city over 6 years results in 3.7 additional apprehensions of not all migrants, just unaccompanied child migrants from that city. All right? And if you're sort of thinking about the magnitude of the effect, that's as large as the magnitude of the effect of poverty. It's as large as the magnitude of the effect from changes in employment possibilities, right? And so one of the things you're seeing from the Northern Triangle is that people are living in a state of crisis, all right? So it is not surprising under those conditions, as we see across the world, if people are living in a state of crisis, they will try to leave, okay? So let's look at sort of changes in the migration flow from Central America. 2014 to 2015, many of you will remember that we had a crisis of unaccompanied child migrants. And what you saw was a dramatic increase in the number of unaccompanied child migrants who are coming. Now, most of these were teenagers, over 80% were teenagers, but you did see one of the things that was notable about this crisis is that there was a dramatic increase in young children who were coming without their parents. That is, a quarter of the flow from both El Salvador and Honduras was children under 12. Okay? And then about 10% of that flow was, 10% of the flow from Guatemala was children under 12. Okay? But while we were focused on the problem of unaccompanied child migrants, we often failed to see that something else was happening at the same time. And that is, as Sherry referred to earlier, that family units were also coming. That is, women and children. Okay? And so I'll get out of this again and show you this picture. So obviously you can't see the numbers. What this is it's plotting unaccompanied children and family unit members who are apprehended at the southern border from 2009 through 2017. The green are family units, the blue are unaccompanied children. And so if you follow that blue, that blue plotting, you can see sort of a steady flow of unaccompanied children that increases, and that's a little harder to see, but it increases dramatically in 2014, and it increases again in 2015. What you also see, though, is that starting from around 2013, you have a population of family units, again, generally women and children coming, and they are also spiking at some of the same times. Right? And then if you look, this is a little harder to tell, but if you look at the blue section sort of plateaus. The number's high, but it plateaus. And the green section goes up. And one of the things that's showing us is that the problem that looked like was suddenly confronting us this year is actually not a problem that's suddenly confronting us. It's a problem from a couple of years back. All right. In 2017, you see a decrease in all apprehensions at the border. Family units, unaccompanied child, single, male apprehensions, all of those things decrease. In 2018, they come back, right? And so what's happening with that population? One of the things that I think is really notable is that when you talk to this population, they talk about two kinds of factors. One is the importance of rejoining family. That is, people who are already, family members who are already in the United States. And the second is the importance of seeking asylum. All right, so what does that asylum process look like? If you are an adult seeking asylum, you're basically given what's called you can do it in two ways. You can show up at a border crossing point. So a place where, like Detroit and Windsor, there is an established Customs and Border Patrol crossing point. And at that point, you can ask for asylum. That is perfectly legal. Under our laws, that is a legal activity to show up in the border and ask for asylum. They are not breaking any laws if they do that. You can also cross the border, and if or when you are apprehended, you can claim asylum defensively, that is, to protect yourself from being sent, deported, returned to your country of origin. That screen is called a credible fear interview. And basically, it seeks to discover whether you are in fear of persecution, and we'll talk about that a little later. If you came to the U.S. because you were fearful of persecution, or you would face persecution, or you would face persecution if you returned. Okay. If you're a child unaccompanied coming to the U.S., there is an additional screen. Because one of the things that the U.S. is concerned about is the problem of human trafficking. And so one of the things that unaccompanied minors are asked about is whether they have been, they are victims of traffickers. If they are not persecuted, if they are not in danger, then they can be sent home. If they are, however, victims of trafficking, potential victims of trafficking, or potentially people who've claimed persecution, then HHS takes custody. They are placed in family, shelter, or foster care placement, thanks to a Flores decision in 1997, which is basically a settlement between advocates and the U.S. government that said, when children are, as part of a family or individually, found to have violated immigration laws by crossing the border, they should be placed, when possible, with a family member, if not possible, with another adult who knows them, only, and then otherwise in the least restrictive condition possible, either in foster care or in a shelter. Okay. And they are in that placement until their asylum claim can be fully processed by the U.S. government. Between 2014 and 2016, remember that spike of apprehensions. Out of 31,000 unaccompanied children, unaccompanied children who asked for asylum, 31,000 unaccompanied children who asked for asylum, 86 received any sort of immigration relief. That's asylum or prevention of deportation, withholding of removal, and I'll talk a little bit about that difference later, or some other benefit. They were found victims of trafficking and therefore, able to move into a different line. But 0.3% received any immigration relief. Right? So what happened to all of those other 30,900 something children? They were at different stages of the process returned to Central America. They either voluntarily or the U.S. government deported them, or they disappeared into the interior. All right. So Sherry's already talked a lot about zero tolerance. What I just want to show you is the change in the process. Okay, so I just talked about you're screened for whether or not you come and ask for asylum at a border entry point, or you are caught crossing the border, and then you're screened. You get this credible fear screening. All right. So what the zero tolerance policy said is that anybody who's coming across the border, not at a border checkpoint, right, will go into criminal proceedings. Being in the U.S. without inspection, without a visa, without a valid visa, is a civil infraction. Okay, it's a civil, it's a civil problem. But crossing the border without permission is a criminal misdemeanor. Okay, and it can be punished by up to 6 months in jail. Prior to this zero tolerance policy, if you were caught with the assumption that you were probably not that you had been in the U.S. for a while, but you were caught recently coming across the border, the expectation is that you would be fingerprinted. The civil infraction would be charged because that has an impact on whether you can come to the U.S. legally later on, but then you would be deported to return to the country of origin. What the Trump administration decided to do is say, we are going to charge all of these people with the crime of crossing the border. That means that unless they can provide bail, which guess what, they can't, they'll be placed into detention until they can come before a judge, and then before a judge, they will generally plead guilty and then be sent back. The aim for doing that is the bans on returning to the U.S. legally are longer. But it also triggers another issue, right? Which is, well, if you're going to detain people until they can go before a judge and then get sent back to their country, then what if you're bringing children with you? Well, children aren't allowed to be detained in adult jails. So as a result of this policy to prosecute, children were separated from adults. There's another important piece of this, which is that if you crossed the border, again, not a proper entry point, and had been apprehended, prior to this, you could go through that credible fear interview and raise the issue of defensive asylum, claiming asylum as part of protection against prosecution. The Trump administration decided that you would no longer be allowed to use the positive result of a credible fear interview to divert you into a different stream. Instead, everybody would be prosecuted first, and then during the trial, you could raise the possibility of making an asylum claim as a defense against being found guilty. But in order to do that, that's a pretty subtle change, but it's a very important legal change, because you now have a bunch of people who are coming across, and unless they are informed that they can raise asylum as a defense against being deported, they won't do it, right? So we've changed from a credible fear renewal, which is triggered by your asking for asylum in front of a U.S. Customs and Border Patrol agent, to something where you can only raise it in the context of a criminal case. That's the policy. Here's the implementation. If you're going to create zero tolerance as a policy, and if as a result of that families are going to be separated from children, you could still imagine maybe tracking children and parents together, so that maybe you would know which parents and which children belong together. The Trump administration did not do this, period. You might consider that if you were going to create a zero tolerance policy where parents and children were going to be separated, you might, before you separated the children, interview them and their parents to see if there was a Flores compliant placement. That is, was there some adult in the U.S. that the children could be released to? The U.S. government decided not to do any Flores determination, Flores placement determination, prior to separation or during the separation process. If you were going to create a zero tolerance policy, you might decide that you would want to prepare for the number of, you might sort of say, well, how many family units are coming across the border? And once we start separating people, how many children are we going to have to provide placements for? There was no preparation for the mass detention of children. And importantly, there was no consideration of the fact that as soon as you separated the children from the parents, then the children became unaccompanied, which triggered a set of asylum protections for them. And although the children were legally entitled, and remember, this is a problem that the administration creates for itself, because it didn't have to separate the children from the parents, in which case the children would have no right to the individual asylum claim. But once you separate them, the children have a right to a determination, and there was absolutely no consideration of how you would adjust to that sort of intersection of law and policy. Okay. So where does this leave us? It primarily leaves us in a place where Jim Hathaway is going to tell us about international asylum policy, but I just want to sort of give you a sense of what the options have been in the United States. The U.S. follows international law. That is, we say that we, like other countries that have signed on to UN conventions on refugees, that refugee status can be claimed when somebody has a well-founded fear of persecution due to their race or ethnicity, their religion, their nationality, their political belief, or membership in the social group. And we can talk about what membership in the social group means later. There are two kinds of people who have the ability to claim this type of protection. One is a group that we call refugees. Refugees make an application for refugee protection from a third country. That is, not from their own country where they are being persecuted, and not in the country that they want to go to, but in a country of first refuge, a country that they run to for protection from the persecution that they are suffering. If you think about Syrian refugees who are trying to come to the US, Syrian refugees are refugees because they're coming from a third country, okay? It also applies to people who make this claim in the US. And generally, these are people who have come to the US legally, perhaps on a student visa, for instance, or a tourist visa, and then claim asylum. So asylum is for people claiming it from within the country that you want that protection for. If you are accepted as a refugee or asylee under international law, the US government provides a set of benefits to you. And one of those benefits is the ability to claim permanent residence, to get a green card, which of course is also a path to citizenship. There is another possibility, which is that you don't have a claim you haven't been persecuted because of one of these five factors, but you are claiming that if you are now returned, that you are in fear of physical harm. This is called withholding of removal. The US government says, we have the right to remove you because you have no right to stay, but we're going to withhold removal. We're not going to deport you just yet. And the important difference is that this comes without permanent residence. And the important new policy change as of last Friday is that the Trump administration has issued an executive order that says anybody coming from these Northern Triangle countries who does not make a claim for asylum at a port of entry will only be permitted to claim withholding of removal. They will not be eligible to make an asylum claim. Whether that's a violation of international law, I'm sure Jim will talk to us about, but this is a really dramatic change in our asylum system. And it is one that, because we've all been preoccupied with the results of the election, no one's really been talking about. All right. In addition to these two, there are also a couple of other possibilities. Remember that spike into around 2000. Both Honduras and El Salvador were granted, people from Honduras and El Salvador who were in the US, from the Honduras in 1999, El Salvador 2001, could claim temporary protected status, which is a status that says, again, you have no permission to be in the US, you have no legal status, you cannot become a permanent resident, but there is a reason why you can't return to your country because of civil war, because of natural disasters, and therefore, for a period of 6 months at a time, we will allow you to stay in the US. Temporary protected status has been canceled for El Salvador by the Trump administration. People who had TPS were supposed to have left by 2018. There's currently a court injunction that keeps them here while the case is being heard. The Trump administration has also ended temporary protected status from the Honduras, and it will expire in January 2020. There's one other possibility, and the final possibility is that we treat people who are coming from the Northern Triangle who are suffering from violence as refugees, that we allow them to go through a refugee process where they could apply either from a third country of refuge, potentially Mexico, or they could actually apply from within their country of origin. And the Obama administration made it possible for some children to apply for refugee status from within their country of origin. That was ended by the Trump administration, and so that possibility no longer exists. And that, I think, leaves us with a final possibility, right, which is if we take the violence that Central Americans are experiencing seriously, we could do what other countries across the world do. That is, we could become a country of first refuge. We could create a set of refugee camps for people who are escaping dire conditions with no obligation to take those people as permanent residents or any kind of residents within the U.S. proper. If this sounds like a crazy idea, what I would remind you is that all across the Middle East, countries that are much smaller and much poorer and much more unstable than we are, Lebanon, Jordan, Turkey, have taken millions of refugees over the last 5 years. And the U.S., despite the fact that we are wealthy, despite the fact that we are safe, has not found it at all, has not felt any pressure to respond in the same way to violence within our hemisphere, violence which over time we have had some responsibility in creating. Thank you.
I thought at this point in the evening you deserve some comic relief. It's not bad, right? It's really interesting to think about perspective when we think about the allegations that have been made by the administration about the inappropriateness of children coming with their parents to seek protection, and the legitimacy, therefore, of separating them as an act of appropriate responsiveness. One might imagine what would have happened, since it's nearly Thanksgiving, had the Pilgrims encountered a similar reaction from the original inhabitants of this place. So far, we've heard about why detaining refugee kids and separating them from their parents is terrible socially. We've heard about how the U.S. has created that policy and indeed an incredibly convoluted and largely illegal immigration system. What I want to do tonight is to focus on the international legality of what's happening in the United States and to sort of pull back from all of the muckiness of the American system that you heard about in Anne's presentation. My basic point is that the mess that we're seeing reflects a failure by the United States, and I do want to emphasize not just by the Trump administration. This is a long-standing failure of both Democratic and Republican administrations to act in accordance with international law. The truth is we have a problem at 3 levels. We have a problem of refugee children being separated from their parents. We have a problem of the detention of refugees, and most generally, we have a very grave problem in the way that we implement our duties to provide asylum to the persecuted. The 3 combine in a perfect storm of horror in the events we've been recently seeing. So let me begin with the first concern. This is the simplest. May the U.S. lawfully separate asylum-seeking children from their parents? In principle, this is absolutely easy to answer. The most widely ratified human rights treaty in the world, the Convention on the Rights of the Child, is absolutely unambiguous. A child shall not be separated from his or her parents except when the competent authorities subject to judicial review determine that that is in the best interests of the child. In the case of U.S. practice, there is no judicial review and there is no assessment of the best interests of the child. It is completely impossible for the United States to comply with this duty. But you may know that we have a problem. The United States is now, I used to be able to say, one of only 2 countries in the world that has not bound itself by the Convention on the Rights of the Child. I regret to inform you that Somalia has beat us to the punch. So now it is only the United States, of all of the countries in the world, despite all of the rhetoric about caring for kids and families. And again, I emphasize under both Republican and Democratic administrations. that has failed to bind ourselves to the single most widely ratified human rights treaty in the entire world. We have signed it, but we have never ratified it. The best that we can say is that once you've signed it but not ratified it, you can't act so as to defeat it, even if you're not yet bound by it. That's not nothing, but it's not a lot either. We have at least two problems. We'd have to prove that what the U.S. is doing is not just wrong, but actually trying to eradicate the entire principle of protecting children, which is tough. And we'd have to find a state to take the U.S. to the International Court of Justice, which probably we're not going to find, because even the Secretary General of the bloody United Nations cannot bring himself to say that what the United States is doing is unlawful. The most that the Secretary General has been able to muster the courage to say is that he thinks refugees and migrants should be treated with respect and dignity. Whoop-de-doo. Thank you for the courageous intervention, Mr. Secretary General. That then pushes us out to the second level, the detention of asylum seekers more generally. Is there a prohibition on the detention of detaining people arriving to seek asylum? Here we are on more solid international legal ground. Instead of the Convention on the Rights of the Child, we move to a treaty that the U.S. actually has signed and ratified and is bound by, the International Covenant on Civil and Political Rights, which provides that the detention of any person under U.S. jurisdiction may only occur when the government proves the onus is on the government to show that it is necessary. In other words, there can be no routine detention of migrants or anyone else. The onus is always on the government to demonstrate that there is no less intrusive mechanism, for example, a reporting requirement or an ankle bracelet, that would meet its needs to know that asylum seekers will show up for their hearings. The U.S. has for many decades followed a policy of routinely detaining asylum seekers in a way that is also discriminatory under this treaty, in that it does not provide those individuals with the benefit of equal benefit of the law. There is zero possibility that the U.S. policy of routinely detaining asylum seekers is legal under a treaty that we have this time signed and agreed to be bound by. Or have we? Because while we are formal party to the treaty, when we actually ratified it, we said that this treaty would not be, in the technical words, self-executing, meaning that nobody under U.S. jurisdiction can invoke the obligation that we have in fact assumed in order to get a remedy from a court. That's quite the interesting notion of actually agreeing to be bound. Moreover, the U.S. Supreme Court determined just last year in a case called Jennings against Rodriguez that the Immigration and Naturalization Act, quote, could not plausibly be interpreted, unquote, as even imposing a duty to inquire into the legality of detention after 6 months of detention. So our domestic courts are not intervening, and the government is precluding them from relying on international law. Thankfully, the covenant is not our only point of departure. We have a third treaty, to which, again, we are a party, which is the UN Refugee Convention and Protocol, which we signed on to in 1968. In this treaty, the rules are especially clear. Perhaps most importantly, even more importantly than previously, people cannot be penalized for arriving to seek protection. They are not doing anything illegal. This whole notion of border point, non-border point is complete, utter legal garbage. You are entitled to arrive wherever you wish to arrive in order to seek protection. Your only duty is to come forward, make a clean breast of the fact that you've done so, and claim protection. At that point, it is patently, absolutely illegal to impose a penalty of any kind for an asylum seeker who has come across the border without a visa. Indeed, not a single country in the world, including this one, will grant you a visa to come seek asylum. By definition, every refugee arrives illegally because there is no other alternative. The drafters of the Refugee Convention knew that and demanded that non-penalization be the norm. Indeed, there is also a duty that as soon as an individual has arrived to claim protection, identified him or herself and satisfied security concerns, what lawyers call regularization of status, even before the claim has been determined, she cannot be detained. It is clear. There is nothing ambiguous about this. Well, you might say these are the rights of refugees. How do we know that these people really are refugees? Well, the drafters of the convention, including, by the way, led by the United States, came up with an answer to that as well. Refugee status is not based on an affirmative finding at a hearing. A person is to be presumed to be a refugee until and unless she is found not to be. And the reason for that is that while a state can require a person under its jurisdiction to submit to its authority, a refugee couldn't force a state to actually hear the claim. The American drafter led the charge, saying that we had to effectively have a reverse onus, that we had to treat people claiming to be refugees as such until the state, under a fair process, proved that they were not. And you can see on the screen where the handbook of the UN High Commissioner for Refugees, which state parties have approved, again, including the United States, says not once, not twice, not 3 times, but 4 times, that refugee status assessment only declares what already exists. In other words, the rights to non-detention and non-penalization adhere until and unless the United States finds the person not to be a refugee. But this brings us to the third and gravest of the problems, the whole U.S. asylum system. All of this distinction between refugees and asylum and asylees is completely, utterly bogus as a matter of international law. The system that Anne described does not map onto the duties that the U.S. helped to create and by which it is bound. Far from respecting the declaratory nature of refugee status that we helped to establish, the United States takes the view that someone who meets the refugee definition that we've agreed to and that we've said no country can lawfully change, that all such people are entitled to absolutely nothing in the United States, even though the treaty itself says they are entitled to a whole range of human rights that I'll come to in a moment. Specifically, the United States has a couple of crazy systems. We are the only country in the world that has multiple systems. Every other country has one refugee system that figures out if you are a refugee and then gives you refugee rights. God forbid we should do exactly what the treaty says we should do. No, we come up with a whole slew of systems, none of which implements our obligations. So we have a system called withholding, which actually doesn't use the refugee definition that we've agreed that no country can change. Instead of talking about a well-founded fear, which our Supreme Court says a 10% chance of the harm is good enough to meet that standard, we say you only get withholding, this remedy, if you can prove 50% plus 1 that the bad thing is going to happen to you. That is an incredibly hard standard to meet if you're projecting forward-looking risk in a country often far away and about which the decision maker likely knows nothing, being heard in a language she probably doesn't speak, across a cultural divide that she likely has difficulty navigating. Even the refugees who get it only get pretty bare bones protection in the U.S., what goes by the label non-refoulement. You may not be sent back to the place of being persecuted. But you don't get the right to work that the Refugee Convention requires that you get. You don't get the right to family reunification. You can't even leave the United States without abandoning your claim. You will never get permanent residency. And by the way, if we can find some other country to dump you in, you are on your way. That's what you get if you meet the super refugee standard, the one that is higher than what international law requires. All of these rights are what a person who meets the plain old refugee standard are entitled to. These are not negotiable. The U.S. does not have the right not to honor these obligations. We created the system within which these obligations are mandatory for a person who qualifies as a refugee. And yet our Supreme Court has said, if you can only meet the refugee definition, the thing that the treaty we helped to draft and signed says gives you all of these rights, you are not entitled to anything. I'm not making this up. I mean, and by the way, you can see the date. This is long before the current constellation of the U.S. Supreme Court. You're not entitled to anything. All you can do is ask the Attorney General whether he might like to give you something. So what is that then? Well, if you meet the actual international legal definition, a well-founded fear of being persecuted for one of 5 reasons, the definition we've got is more or less right. There are some technical problems with it, but it's close enough. It's only since the mid-1990s that we've even said we won't send you home. We didn't do that before. We used to grant most other rights in practice, although we didn't obligate ourselves to do so. But now we've said, if you don't come forward, we're not going to give you those. Oh, by the way, it took you more than a year, as it does, for example, for many at-risk women and sexual minorities who don't even know that they have the basis for an asylum claim. If you come forward 1 year and 1 day later, you're entitled to nothing under this system. Oh, by the way, if you could have asked for protection somewhere else but you didn't, too bad. We're not going to give you protection. Oh, by the way, and this is a big by the way, even if you meet all of the tests we've set, we still don't have to give you anything. Now, that used to look like a bit of a paper threat, but last summer, in a decision called Matter of AB, the then Attorney General, this is another lovely thing, we have this lovely rule that the Attorney General, a political appointee, can override the top administrative tribunal on refugee status. So much for the rule of law. I don't want to see the U.S. lecturing any other country about the rule of law as long as we have this system. A political appointee single-handedly overrules the judicial process on asylum. And he said, by the way, guys, let's get it straight. This discretion is not a paper tiger. This is a discrete requirement that you may not gloss over, and I expect you to use it. And by the way, I'm going to use it for a whole lot of stuff. In fact, he said, I'll use it if you don't come to a legitimate border point. That's where the current policy that we're seeing came from. So this is kind of the parallel universe in which we're living. I see some of my students in the room who are thinking, what the heck, right? We've just spent 36 hours learning the UN refugee definition that the US barely respects. We've done an entire workshop on the rights of refugees under international law that the US denies exist. Why are we living in this universe? The problems are not as simple as detaining kids or separating them from their parents. Our entire system is essentially unlawful. We are not in any way, shape, or form living up to a deal that, again, I want to emphasize, the U.S. was the lead drafter of this convention, right? We will only now, if you show up at an unlawful border point, which of course is lawful under the treaty, but let me just subject you to this withholding system, which has the heavier burden of proof, which means that a lot of people who are entitled to refugee status will not get it and will be sent home. That is as clear an unlawful penalty as you could possibly imagine under international refugee law. It is the equivalent of the death penalty. So the bottom line is that the U.S. has found domestic ways to avoid the prohibition of separating children from their parents, to avoid the duty not to detain refugee claimants other than briefly and after showing it to be necessary in the individual case, and generally to give asylum to people who meet the agreed definition of a refugee, including all of the rights that go with it. This is not just a series of acts that are internationally prohibited, but they are acts that are, as the cartoon suggested, fundamentally at odds with our own core values and with our own history. Thank you.
Thank you. If all the panelists could come forward and sit in. We don't have a lot of time for questions, so we'll take them in bunches. If you could raise your hand, and Brina will bring a microphone to you.
What might be the consequences, Professor Hathaway here? What might be the consequences of some other nation or even an individual taking the United States to the World Court over its violation of its treaties?
Take maybe 2 more questions.
I just wonder, there's a few things that have been troubling me through this whole process. One is sort of that apparently a number of the children are disappearing. And do we have any knowledge about connections between this detention policy and trafficking of those children? And do we have any knowledge about sort of connections between this policy and sort of the fact that so much of it is private contracted, so there's the perverse incentive to be incarcerating more and more individuals in yet another of our various incarceration systems?
For Professor Hathaway, you mentioned that, I forget exactly which treaty you said was non-self-executing.
The Covenant.
The Covenant.
Political rights.
Are there instances where there are individual states that are taking it upon themselves to abide by the Covenant, even though the federal government is not doing so? And if so, how do those states come into conflict with current federal policies, and like what's the backlash that they find?
Great. Well,
One of you take
Whatever.
the question. Look, the short answer in your first one, the first question is, technically, this is one of the few instances in which the U.S. has no choice if another country that has signed the Refugee Convention wants to take it to the International Court of Justice. It's not an opt-out, so we are bound by it. The tragedy is that never once has another country of any stripe taken another country to the World Court over non-compliance with the Refugee Treaty. And that's likely because each has dirty laundry. The U.S. may have a bit more than others, but it's not as though we're alone on this front. I mean, the European Union, for example, right now is funding Libya to effectively detain and torture refugees captured on the Mediterranean. So, you know, we have some pretty ugly company on this. I've lobbied for years to have for the Refugee Treaty what we have for every other UN human rights treaty, which is an independent supervisory body at least able to declare breaches. We are the only UN human rights treaty without that capacity. And even the UN Refugee Agency will not support it because I think it fears a loss of institutional prestige. So we're in a difficult position. And you're quite right that in theory the option exists, but in practice it's meaningless. Covenant on Civil and Political Rights, are you actually suggesting sort of sanctuary cities? Is that where you're going, or what are you thinking with this? I was just trying to, when you said states, did you mean, because most states do comply with most of what's in the Civil and Political Covenant most of the time, right? I'm not suggesting the U.S., you know, arbitrarily detains people or tortures people or doesn't let them go to court most of the time. What I was suggesting is that on the detention of refugees, on the detention of non-citizens, we have a blind spot. We have a stupid doctrine that goes under the label of plenary power that suggests that we can do whatever we want to non-citizens, and that's just wrong at every level. The human rights bodies have condemned the plenary power doctrine is completely inconsistent with the notion that every human being, whatever her citizenship status, is entitled to only be detained on showing of good cause and to the minimal extent necessary by the circumstances. So any policy of routinely detaining people simply by virtue of their status is unlawful. So if you're asking me whether civil disobedience by a state or a municipality could be justified, I think in Europe we are now beginning to see some instances of this, where, for example, the city of Amsterdam has stood up to the national government and said that it will treat refugees in accordance with the refugee treaty despite national policies going the other direction. But that is a nascent movement. It's largely municipal rather than state or Länder-based.
Let me just add two things about the about UNHCR and why it might not hold the take action against the United States. 1% of the world's refugees ever get resettled in a third country. All right. So there are, in other words, there are 99% of people in the world who have a fear of persecution and could claim the right to have another country protect them, will never get resettled. Now, partly that's because we generally hope that refugees will be able to return to their own country, will be repatriated. And repatriation is a sort of the first option that UNHCR pursues as a matter of practice. On the other hand, it's important to recognize that waiting around for repatriation can take decades. And in fact, UNHCR's refugee camps in many countries have been open for decades, while people wait for the situation in their home countries to stabilize enough that repatriation becomes possible. But so if we go back to that 1% of the world's refugees who are ever resettled in a third country, so in a country that's not the country of refuge and is not their home country, the US is by far the largest provider of resettlement spaces. Now that's not true if you look per capita. Sweden provides more spaces per population than we do. And it is no longer true given the US decision to cut its resettlement quota essentially from 80,000 people, give or take, in the last 10 years, an annual quota of 80,000, to where the Trump administration is now, which is a quota of 35,000 and a lower actual number of people who are accepted for resettlement. So the UNHCR has had an important interest over many years in not cutting off the provision of resettlement spaces by holding the US accountable for its violations of international law. And I think that's just, you can make a decision about whether you think that's reasonable or not. I think that's sort of political reality. On the states issue, I think it's really, the question you raise is really interesting because technically, states can't do the most important thing that refugees and asylees need, right? Which is provide them the right to residence. The U.S. Constitution, I think, makes it reasonably clear that the federal government is in charge of naturalization, right? That is granting citizenship. Whether states have the ability to provide any other sort of residence or to deny the benefits of residence is a really complicated question. And the short answer for this is that if you look in the 19th century, through 19th century immigration law, there's some historical basis to suggest that states might have the ability to take or remove residents, but that the federal government basically preempts states' ability to do that through legislation passed starting from the 1970s and then very clearly by the Supreme Court decisions that in the late 2000s. So whether you could move to a different system, I think, is something that is really interesting, and which I should say if you look at countries like Canada and Australia have immigration systems still governed by their federal immigration system, but immigration systems where provinces or states can affirmatively take the role in selecting and admitting immigrants. And that's something that in the US we have not seen.
Well, I can't speak much to the law, but I did hear a comment about private prisons. And I think that it's important for us to be paying attention to the ways that private prisons are interacting with the Department of Homeland Security and the ways that they have been able to interlace their own needs with the needs of agencies within the Department of Homeland Security like ICE. And one of the things that's happened over the past few years is that the allocations within the budget within the Department of Homeland Security has been upping its number of beds that it will support through the budget. ICE says this is not a requirement that we fill 45,000 beds a night, but somehow or other they do. And much of that money now goes to private prison companies like CoreCivic, which is the great big one in the United States. What we have to pay attention to is the fact that many of these private prison companies are also working within the criminal prison system. And so they have become very big lobbyists in Washington, and their needs are being considered way over the needs of people who might end up in detention.
Thank you. I'm sure there are many more questions, but we have to close our session here. But we do have a reception outside, so I'd like to invite all of you to join us, and then you can ask questions of the...
Kiyo, I think you were supposed to say that there's really good food at the reception.
Thank you. Please join me in thanking the insightful presentation.